the lawyer in blue jeans. He is my dad. He is the person who started this firm. He recently retired, but he's been on local media all around San Diego County and Southern California for quite a while, doing TV and radio. We had a radio show that went up until about last year, but there was some issues with the radio station and they were getting bought out. So we decided to stop that for a while. But we are estate planning attorneys. We have an estate planning firm here in San Diego, and we've been doing this for, 20 plus years now. We have a pretty small firm. We're only about 8 people or so, 9 people, but all we focus on is estate planning. And that's pretty important too, because when you're talking to someone about estate planning, you need someone who only really deals with it, because there's so much to know and it's always changing. Every, 3 times this week, I've already gotten new cases that have come down from Sacramento and our California courts that have changed the way we do certain things of our trust. So having an estate planning attorney who focuses solely on that is a pretty important thing. We actually had a person who, this is a deed issue, who tried to put joint tenancy within a tenancy in common on a deed, and now it's going to go to probate because they didn't talk to an attorney, an estate planning attorney who would be able to tell them, or a property attorney, who would be able to tell them pretty quick that it's not going to work. So it's pretty invaluable, and we like to educate. Our goal is to just give information about the probate process, which a lot of you will see throughout this webinar. And so we usually will do in-person seminars, but since because of COVID, we can't. So we're doing a lot of webinars and webinars just like this for companies to kind of educate people on how to protect yourselves, how to protect your family, especially during a time like this, because realistically, it's a little uncertain. It's kind of scary. And a lot of people just don't know about how estate planning works or how probate works. And that's what we're here for, is to bring that education to you. So should I go back to sharing the screen now?
Sure.
Okay. And do you want to wait another minute, or should we get going?
I'd say go ahead and get going. It's a few minutes after, so if people join, they'll join in the middle.
Okay, not a problem. So let's see here. Am I going to get this clicker to work? Okay. So estate planning, asset protection, how to protect yourself. Our goal is not to, some attorneys want you to constantly be in the office so they can charge you more and more. We don't like that. Our policy is, especially for clients, once a client, you're always a client. You can always call or ask us questions later on. We don't do any billing for something like that. But like I said, we like to be educators on the topic. So most people think when it comes to estate planning that it's boring, but it doesn't have to be boring. And this is kind of a light cartoon that we like to share. I don't know if everyone can see that. I think they can. It kind of shows you that you don't always have to think of this as such a boring thing. We deal with this all the time. So it's kind of interesting because we see different scenarios and constant challenges that come up. But estate planning is not, it's not like litigation. It's not like family law. There's not a lot of drama like that. There are some fights between family members, but our goal is to mitigate that as much as possible, or make your estate plan as airtight as possible so we don't have fights. And if we do have fights, they don't really go anywhere because we don't want to go to court. So we're going to talk about that a little bit more as well. At this point, usually in our presentation, we'll say, how many of you have planned your estate? And you can raise your hand and say, oh, I have or I haven't. And most people say that they haven't. But the answer is really that all of you have. Because if you haven't put a plan in place, you still have planned your estate in a different way, and that's by going intestate. So when you pass away intestate, that means you're telling the government, you decide. I have no decision-making skills. I have no will. I have no trust. The government decides who's going to get what, and you have no control. So when you have an estate plan, you have the maximum amount of control. Even if you have a will, you're still going to go to probate and you have a little bit of control, but that's still better than not having anything at all. So that's the important thing, is just putting a plan in place. Now, there are a few ways that some people try and plan your estate and get around having to do a trust or some other thing, but it might be, like I said, do nothing, intestate succession, where the government's formula decides who gets your stuff. Also, a will. And like I said, a will goes to probate. So most people think that that's what you need in the state of California, but no, you need more than that usually. Now, some people don't need a will. If you own property, or if you have more than $166,000 in total assets, or if you have minor children, any of those three will trigger the need for a trust. If you don't have all of those three, any of those three, then you probably don't need a trust and you might be okay with just a will. But most people in California who have a property, you need a trust because otherwise it's going to go through probate. And we're going to talk about why that's such a bad process and why it's so long. Some people have their properties in joint tenancy, and we're going to talk about why that doesn't work in the long term either. It might in the short term. And also people think, well, I'll just put my kids on as a beneficiary and that's going to avoid probate. Might, and it might not. And also, as a side note too, I'm going to go off on a little bit of a tangent here. If you know anyone, or if you have someone on your bank account or on your property and they're your kids or someone else, not your significant other, you might want to reconsider that, because if you have, say, your kids on, one of your kids on as a co-owner of your bank account so they can pay your bills in case something happens to you, if they get in a car accident and someone sues your child, they could take your money. Or if they're on as a co-owner of your house, they could take your house. Even though they don't actually own it, they're just on the title or on the bank account, they can still take it because they're perceived as a co-owner. So it's something really you want to be cautious about because that happens sometimes and it's a really unfortunate thing. Also, you can give away gifts in order to avoid going to the probate court. $15,000 a year. And that might not be the best plan of attack as well, because what happens if we have a downturn in the economy like we're in right now and you need that money back? Well, are your kids going to give it back? Well, probably not, They probably can't as well, because usually we don't just hold it, So we're going to get into, I have to kind of speed through some of these joint tenancy ones too, but I think a lot of people kind of know how joint tenancy works. But Jake and Jan are married. They purchased a small house for $400,000. They were told that their best way to title the house was joint tenancy and that the survivor would inherit the house free of probate. Now, is that true? Technically, kind of, because if Jake dies, then what happens? Does Jan get the house automatically? Maybe, but not necessarily, because what if Jake dies and then what if Jan dies? Then we're going to probate. What if Jan is incapacitated at the time that Jake dies? Then we're going to probate. What if Jan dies before Jake? Then we're going to probate. So you see here that Jan might inherit the house free and clear for a while, but when she passes away, it's going to go to probate. And so joint tenancy is a temporary solution. It is not a long-term solution, because when you have your assets go through the trust, you don't have to worry about dealing with the probate court in any capacity. So joint tenancy number 2, what about Jake and Jan when they have a 2-year-old, right? They purchase the house in joint tenancy. Jake dies and leaving Jan and the baby, right? A young baby. So this happens, unfortunately, all too often. These are the kind of sudden deaths that we really don't want to think about, but happen very frequently. And it's why it's so important for young parents, especially, to have a plan in place because of something like this. So Jan and the baby, they're in mourning, and what do? They decide to go to Tahiti to kind of shake it off, to recoup, and then what happens in Tahiti? Jan meets Macho Man. So what does she do? She marries Macho Man, puts him on as a joint tenant, and then when she passes away, what happens to the property? Well, at that point, Macho Man inherits the house and the baby gets nothing. So again, this is not a plan. This is just kind of a temporary solution, pushing the property off to the next person that's on as a joint tenant. And again, I don't think that Jake or Jan would want their baby to be skipped over, but that's how joint tenancy works. The baby, even if the baby's over 18 at that point, they don't have any claim for it because Macho was a co-owner of the house. So capital gains, this is an important one too. And I'm going to give a personal story about this too with one of our clients. A story of Jack and Jill. They bought their house in 1960 for $30,000, made some improvements. Jack died in 96, and the home value is $400,000 at that point. Jill is now selling the house. What would the capital gains exposure be if the house sells for $650,000? Excuse me. Just a tickle in my throat. It's not COVID. Titled in joint tenancy, Jill's taxable capital gain, $175,000. That is a lot of exposure to capital gains. Now, when you have it titled through your trust, zero. So I have a personal story I'm going to veer off on for this for just a second. I had a client who was not doing very well, and we were going to go sign her trust in the hospital, right? So I went to the hospital, I signed everything. She was skipping over her first 2 born children, and she wanted everything to go to her last child, right? So I verified everything with her. I made sure it's exactly what she wanted, because she wanted to make sure that that property went to child number 3. So a couple days later, I get a call from her, and she said, look, I'm going to put my daughter on as a joint tenant. My CPA or my accountant told me that this is a good idea because the property will go to her directly. And I said, please do not do that. You've owned this property for a long time. This will screw everything up, and you're going to owe, your estate will owe in taxes. And she said, okay, I'll think about it. And then she passed away a couple days later. Her daughter came to me about 9 months later and said, look, my mom died. And I said, oh, I'm really sorry to hear that. And she said, also, she put me on as a joint tenant right before she passed away. And I said, oh, no. She said, I owe $90,000 in capital gains. What can I do? How do I unwind this whole thing? And I said, you can't. It is all now in stone. You can't get that property without paying those capital gains. It's unfortunate. It's the problem with not consulting with an actual attorney on something like that. Whereas, you know, she talked to her, it wasn't even her accountant, it was her tax preparer who told her to do this. Because she just knew that joint tenancy means that the person automatically assumes the property. And I said, well, you know, she should have known about the capital gains issue, but essentially you have to pay that. And so the daughter, she ended up getting the property, but if it went through the trust, she wouldn't have to sell the property like she did in order to satisfy those taxes. So it's a cautionary tale. And also the one I mentioned earlier about 4 people trying to get a double joint tenancy within a tenancy in common on a deed, and it's going to probate too for a small portion. It's a huge mess. So it's important to listen to people, listen to the professionals on something like that. I'm not tooting my own horn here. I'm just saying it comes up too often where we try and cut corners, and that's common. I try and do it all the time too. And so we'll talk about that a little bit more in just a bit. Because, and like I said, you get the full step up in cost basis when it comes to capital gains tax. And that's why it's such a valuable tool, where any assets that appreciate, whether it be property or stocks, bonds, mutual funds, things like that, there is no actual capital gain because of the trust. So another bonus and benefit. So let's talk about probate and what that is. Now, if anyone doesn't know what the probate process is, really it is the court proceedings to hand off your stuff to your family members or whomever you choose, right? So in order to avoid the probate court, the legislature has come up with this idea of a living trust where we can exempt ourselves from the court. So that's what you're doing when you have a trust or an estate plan, is exempting yourself from the courts, and only you're essentially taking control into your hands and not dealing with the courts. So probate does take time. It's very expensive. And it is, like I said, dealing with the courts. It controls every part of inheritance. And if you don't have a will, if you do have a will, we have to validate that will and control every element of distribution. They also pay your debts, but it is the only legal way to change title to property unless you have a trust. Someone asked me one time, Justin, what is because we're starting a probate for a client who did a trust with us, but their parents did not. And we're starting the probate, and he said, what's it going to be like? What's this whole process going to be like? You know, kind of break it down for me. I said, well, it's like going to the DMV for 2 years straight. And that's exactly what it's like. Now, I need to alter that a bit because COVID has pushed everything back. So it might be about 3 years on average. We've seen some long ones, and we've seen, you know, ones that are about 1.5 years. The Riverside probates that we have are particularly frustrating because the judge there likes to kick stuff down the line just to not deal with it at that moment. Even though they tend to be easy issues. He's a big fan of granting extensions or you know, calling for extensions when not necessary at all. So the cost of probate, right? So in San Diego, well, in probates in general for California, The probate fees are based on the gross value of your estate, not the net, but the gross. That's an important thing too, because if you buy a $600,000 piece of property and you owe $550,000 on it, your equity is $50,000, but your fees for your probate is $600,000. It's based on that number, not the net, which is a really gross way of looking at it, pardon the pun. But the courts do give you 9 months to pay. Thank you very much. We appreciate that. Small penalty if you don't pay. That's expected. It's the government. But what is that small penalty in their eyes? It's 5% per month. That's 60% per year. That's insanity to think about. I don't know what's more gross, the gross value or the 5% thing. So it's not a good system. You know, we're incentivized as Americans, the American dream, buy a house, you know, where there's all these bonuses and benefits to getting property, and then they go and do something like that. But they don't tell you about a trust and how you can avoid all of this. So probate does take time. And why does it take time? Well, everything is frozen while your probate proceeding is going. So if you were to pass away, all of your accounts, your property, anything that you own, frozen, locked in. Courts will be the only ones that can release it. So we need that probate order to release those assets. And on average, like I said, it's 2 years for a probate. The longest that we've seen, 21 years. So imagine this. We open up a probate and a child is just born. That child turns 21, is able to start drinking, and we're closing the probate. That is crazy to think about. Now, say for instance, you had a will, right? Pretty typical for people to have a will. 72% of Americans don't have a trust. So the majority of people have a will or have nothing. Now, say you write in your will that you want your favorite nephew to receive $5,000, right? As a stipulation of your will when you pass away. And your nephew breaks his leg right when you passed away, you know, really saddened by the news, and breaks his leg, just happened to, and needed $1,000 for the cast or whatever, you know, was necessary. Now, in order to get access to that $5,000, we need a probate order to release those assets. So we have to get in front of a judge just to try and get an advance against that $5,000. And just to get in front of a judge right now is about 6 months. So there's no guarantee that that judge at that moment will even say, yes, you can have $1,000 ahead of time. They might actually kick it down the line. So it might be 12 months or 9 months. But what happens at that point? Your nephew's leg is mishealed and he's in collections because he couldn't get that money. He couldn't get the cast or you know, vice versa. So it's important to know that when you have like the courts involved, you're constantly dealing with the courts. But if you have a trust, you go up to the trustee, the nephew would go up to your trustee and say, Mr. Trustee, Mrs. Trustee, I need $1,000 against my inheritance that I'm supposed to get from my uncle's trust. And then they take out the checkbook and just write a check. Here you go. There's an advance against your inheritance. So it's important to know how easy it is when you have an estate plan as opposed to having a trust and having to deal with the bureaucracy, with the courts, with the filings, and oh, it is a nightmare. So why is it so bad? Why does it take so long? Well, in San Diego, we only have 3 probate judges for 3.6 million people. And that is insanity to me because they don't just deal with probates of estates that don't have a trust. They deal with people who didn't have a power of attorney and they're incapacitated. They deal with minor children whose parents didn't have an estate plan. They deal with all kinds of stuff, not just what I'm talking about right now. So 3.6 million people, 3 judges. So we have 1.2 million people per dedicated judge. And most of those people, the majority of those people don't have a trust. So when you have a trust, there is no government involvement except for one thing. We need the death certificate. We can really get working from there, but that's the only governmental document that we need from them. It is exempt from probate, but it can be administered within a few months, a few years, whatever you decide. A trust is so important because you can put rules and restrictions on it. You're in charge. So if you have a 10-year-old, right? Well, we don't want them to receive a big chunk of inheritance if something happens to you suddenly. You want that to be structured out for them. So at 18, legally, they can have it, but why would you want to do that? Usually kids don't, mature by age 18. So commonly people will come to us and say, okay, I want to do like a third at 21 or college graduation, whichever comes first, a third at 25 and a third at 30, or whatever terms that you determine. It's important for you to make the decisions about your estate plan because you know your family best. So you're in control. And taxes, I'll kind of breeze through this one. So if you have less than $11 million or less than 23 million, then you're not going to be taxed, right? Now, a caveat to that is that California does not have an inheritance tax, but they are putting on the ballot an estate tax for assets or estates worth more than $3 million or $6 million combined. That will be on the November ballot from what we're told. It's not very popular. Vote on it as you will. I'm not a huge fan of it because all these dollars are already taxed. So we should ultimately, I think we should be able to decide who it goes to. So, you know, think about that, but that's look out for that on the ballot, and I'll probably be doing a write-up on that pretty soon too when we know a little bit more. So probably the most important part, what happens to our kids if we have minor children? Remember I mentioned one of the three triggers for the need for a trust is if you have minor children. Where do they go if you don't have an estate plan? Well, pure and simple, the government. They go to CPS through the probate court. Remember, 3 judges, and ultimately the parents aren't the ones who decide who gets to look after the kids, but a judge will. And granted, that judge might do their best to try and find the best fit for that child, but they're going to have to listen to testimony, and then you might have people fighting in court. You might have grandma number one and grandma on the other side who want to look after that child, but then they start accusing each other of things, and then who loses at that point? The child does. And so it's important to have a plan in place, just making sure that you are documenting who you want your kids to go to. It's just making everything comprehensive and easy for your kids, for your family, so we don't end up in court. That's our goal. Avoid probate court, avoid having to go through all the litigation and the problems that come up with that. So like I said, it's about control, but also privacy as well too. So you have full control of your estate plan. You're the one who gets to decide the terms of your trust. Now, maybe you have someone in your family who has special needs and they're receiving benefits. We don't want them to miss out on those benefits or be disqualified because those are hard to get. So we need to set up a special needs trust within your trust. And that is something that we can do that a good estate planning attorney knows how to do. And so you want to make sure that you have all this in place, but not just that, your documents are private. When you have a trust, everything is private. It's kept, out of the limelight, out of the public view. If you have a will or if you die intestate, as I mentioned, everything is public. So if everyone remembers Prince, Aretha Franklin, they passed away. They didn't have a trust. So we can find out if you have a little bit of time and like $40, you can buy all the documents for their proceedings and know exactly what's going on. And that, might not necessarily feel like it applies to us, but we're all private people to a certain extent. We put a lock on our phone, we lock our door. We want to make sure we keep control of our data. We don't go, advertising it out, even though some companies are stealing our data. But it's important to know that like when you have a trust, it's all private. No one knows about it. No one can find out unless they're listed as someone that you want them to find out and you want them to know about what your estate plan says. So as I mentioned, your trust is revocable. It's something that you can change too. So if you, say you have 2 kids and you want them to receive everything 50-50, and then, you get a new son-in-law who starts kind of nudging you saying, hey, why don't you loan me $50,000 for my new venture here? And you say, oh, I don't know, maybe we want to disinherit this guy because he's kind of sketching us out, or making sure that he can't be a trustee. The main thing is that you can change your trust as your life changes. And sometimes we have falling out with family or, nieces and nephews or siblings. We want to make sure that we are in control of our estate plan and it's not going to go to people that we don't want it to. You've worked hard for your estate, so you should be the one in control of who gets it. So how do you get it done? There's the right way and the wrong way. So the wrong way would be the boilerplate way, the one size fits all. The right way would be the customized way, the specifically tailored to your family's needs. Now, the boilerplate way might be a couple different options. You might download something from Google and paste your name on it. That's probably going to go to probate. You might get someone who doesn't do this for a living, maybe like a Craigslist paralegal that actually comes up quite often. And those paralegals, there's a lot of problems with that. A, it's practicing law without a license. B, they don't get updated with all the new laws. And C, there's no recourse for your family. So if that trust doesn't work that some paralegal made for you, there's no malpractice insurance or no way to ensure that your family can be made whole again, because you're not an attorney. You're not supposedly practicing law without a license. So it's important to see someone, like I said, who knows estate planning, who knows the field of law, and also can create that customized document that your family needs. As I mentioned, what if you have someone who has special needs, or what if you have someone who matures a little bit later? You want to make sure that they're not using money to go on spring break or something like that. You can put all kinds of restrictions in there. Our trusts have drug language in there. In case someone is abusing drugs, the trustee can withhold those funds until they test clean and sober. And these things didn't exist 10 years ago, 5, 10, 15 years ago. So trust law has become very robust and very protective of the person who holds the trust. So you want to be able to change it depending on your life changes. So all trusts are not alike. They're kind of like a fingerprint. Everything is a little bit different, but as I mentioned, there's rules constantly being changed. So you want to make sure that we are constantly updating the trust as well. And most attorneys don't create trust because it is not something that's required in law school. So you can graduate from law school, pass the bar, and start creating trust. And the problem with that is that you won't know if it works until you're already dead, and then you can't change it. And so that's why it's so important to see someone who knows estate planning, who knows trust, who's done this, as their field essentially for a while. And I'm going to kind of zoom through LegalZoom. We've seen some LegalZoom trusts as well too, and LegalZoom actually, they kind of tell you not to use them, and I'm going to explain why or how that is. No, don't get me wrong. LegalZoom is good for small things, name changes, even other small kind of administrative things, but not when it comes to a trust, because they, like I said, they tell you not to use them through their disclaimer. So if you look here, we kind of highlighted in white where it says LegalZoom is not a law firm. Communications between you and LegalZoom are part of the privacy policy, but not attorney-client privilege or work product doctrine, which means they could essentially sell your data. They might be able to, but they also get their data breached. That's happened, I think, once or twice. But at the very bottom, the third line from the bottom says, LegalZoom cannot provide legal advice and can only provide self-help services at your specific direction. So what does that mean? That means that you have to decide all of the ins and outs of the trust. They're just going to type it up for you. So if you have a legal question and you call LegalZoom, they're going to say, whoa, we can't provide legal advice. We can only provide self-help services. So if you can't click a screen, then we'll help you get to that screen, but we can't give you any advice on how to create your trust. So it's a very common thing where people will have a LegalZoom trust. They bring it into us. We realize that it was done the wrong way because the person just didn't know how to create it. It's your own creation software. So it's a very important thing. Again, LegalZoom is not a bad service for small things, but not when it comes to your trust. There's too much at stake here. There's too much that can go wrong. So what about incapacity? How many of us will be incapacitated during our lifetime? The answer is 1 out of every 2. So with your estate plan, you want to make sure you have the incapacity documents attached to it as well. Powers of attorney, healthcare directives. Now, a lot of people think, well, I have a spouse. My spouse will make my decisions for me. That's not true. Unless you have something in writing that says that they can, your spouse cannot make decisions on your behalf. So if you get in a car accident, your spouse comes running in and they say, let me see a power of attorney or a healthcare directive that says that you're appointed. And if you don't have that, the doctors won't say a word to you. They'll talk to you, but you can't make decisions. They might talk to you, actually. So HIPAA is very stringent about that. And I think a lot of people have probably dealt with HIPAA and their restrictions. So what's the alternative? Well, if you don't have a power of attorney, if you don't have a healthcare directive, what do? We have to go to court. We have to get in front of one of those 3 judges, and that's called a conservatorship. Usually takes about a year, and it costs about $10,000 in legal fees. So again, the alternative is just a power of attorney or a healthcare directive in place. It's so easy compared to what it would be through the court proceeding, which is almost as bad as a probate. But remember, a probate is for a lot more too. This is just for someone to make decisions. So it's a pretty bad process in general. That's why it's so important to have those documents in place. So advantages, we went through a lot. I'm going to kind of breeze through it's 2 pages long actually. No court, no probate fees. You don't have to have an attorney. Your trust can be administered from your successor trustee. It saves years of time. That is not an overestimate or an exaggeration. That is an actual fact. The longest probate that I found was 94 years in San Luis Obispo. Now that's obviously that's way, way outside the norm. But that was a family who didn't even know that the property was still in probate for this whole time period. People just forgot about it. So that was crazy. But 2 years, 3 years, that's very much the average, as I mentioned. Avoids multiple probates. What if you have rentals in Arizona or Nevada or in a different state? What if you inherit a property in a different state? Do you need a trust there too? No, you just have one trust. All of your property goes into it. But if you don't have a trust, you're going to have a probate in California, Nevada, Arizona, wherever you own property, you're going to have probates everywhere. And that means you're going to have attorneys everywhere too, because we only usually take one bar. So it's a nightmare, especially if you have multiple properties. Prevents court control upon incapacity. It's private, as I mentioned. It reduces contest by heirs. It's so hard to contest a trust. If you have a will, I can go contest your will, even though I don't know you, and I can slow down the whole proceeding. Me contesting your trust, how? Good luck. I have no legal reason to even be able to get in there because I have no relation to you. So with the will, with intestacy, it's a completely different story. Again, control for minors. You decide when they get their inheritance. It's very easy to maintain. It's all about asset management too. Everything is in one central area. It's all right in front of you for your successor trustee to administer and make it easy for them. There's no inheritance tax. There's no estate tax. There's no capital gains tax. But most importantly, it gives you peace of mind. And that is one thing that we're seeing through this whole COVID crisis is that we're getting a lot of people in here who said, I need to get this done. I've been thinking about this forever. And now COVID's on my mind. So I need help. Tell me what I need to do. And so that's what we're really here for, is to kind of walk people through the process. Now, we like to give disadvantages as well, because we're not just this, hey, this is the greatest thing ever. There are some disadvantages to a trust, or what we've seen throughout the years that the reasons why people don't get a trust, right? So people don't understand it sometimes. That's my fault if you don't understand it. But like I said, we're here to explain it, to explain these documents in this very complex field of law in a much easier to digest manner than some other attorneys might. That's our goal, is just to get this information to you. You make the decision. Of course, we don't expect everyone to use us, but I just want you to know about the benefits of the trust versus having to go through the probate system, because we've seen the alternative and how bad it is. Inertia. You started without a trust. You're going to go through this whole webinar and still not have a trust. So some people just say, oh, I'll do it. I'll get to it eventually. Probably not. As I said, statistically, that number is about 72% of people don't have a trust. And that hasn't really gone up or down throughout the years. So not many people are jumping on the whole trust bandwagon, at least not in a significant way. But we're seeing a lot of people who are more and more interested because it's been in the news a little bit too. So, and then the last one would be cost prohibitive. Some attorneys around Southern California will be anywhere from $5,500 up in LA. You're looking at more like $12,000, Orange County, $12,000, $15,000-ish for a trust. That's a little too much in our eyes. We don't charge nearly that amount. There are people in San Diego and Southern California that will do $8,500 as well. But again, it's a little bit high for us. It's more than what we normally would charge for an estate plan. But that's another disadvantage that people see to it. But if you weigh that versus how much your probate would cost, it's still better than not going to probate for so many different reasons. So with a full estate plan, this is what you should have. You should have a trust. You should have 2 wills, powers of attorney, healthcare directives. Everything should be customized. Now, that will that I mentioned, the pour-over will, that's not like a normal will that's just going to send your estate to probate. This says in your will, I give all of my stuff to my trust. So it's a safety net. the whole goal for that is to pour assets over to your trust, if something were to slip through the cracks. So it's purely a safety net. Everything should go through your trust, but in case it doesn't, we have the backup plan as the will. Power of attorney, this who can pay your bills and sign your checks, do your taxes, and then advanced healthcare directives, who can make your medical decisions. So all these documents should be customized. They shouldn't be just a couple of pages. The trust should, like our trust is like 30 pages, our will is about 10 pages. Power of attorney is 35, I think. Healthcare directives, 12 to 14 pages. So it's important to make sure that these are all customized documents according to what your wishes are. I think that is the end of my presentation. So if there are questions, are we going to open up for questions?
Absolutely.
Okay. So if anyone has any questions, I don't know if there's a question section on here.
We can use the chat function.
Okay.
So everybody, if you guys have questions, go ahead and the bottom of your screen, if you hover over the bottom of your screen, you can ask them within chat. There was one question, I think you mentioned this already, but there was one question right now that says, are your services good in all states?
I cannot, if you're located in California currently, I can create a trust for you. If you move, I can still continue to create estate planning documents or amendments for you. But if you currently reside outside of California, you don't own any property here in California, I probably couldn't do your trust. It's kind of a gray area, but it's not, better safe than sorry.
Yeah.
So mainly just California, but we have clients all the way up the state. We have San Francisco clients and Sacramento and whatnot. We do a lot through Zoom. We do a lot through email. So we can take clients wherever throughout the state.
While we're waiting for questions to come in, I'll ask a few questions.
Sure.
You had mentioned that there were 3 probate judges in San Diego County.
Uh-huh.
How many in Riverside County?
I had to double check on that. I think there's 4, but don't hold me to that. I know there's one that we've dealt with mainly. There actually might not be 4. There might be 2. There's one that we've dealt with. I don't want to name his name on here, but he caused a delay in our probate up there for about a year. We were essentially trying to get, so the situation was the parent passed away and there was 2 kids, right? Child number 1 was made the executor, right? And then he passed away before the probate finished and 2 days before the sale of the house. So now we have no one who has power and authority to sell the house. So we need to get the other child appointed as executor. That took about 10 months because that judge arbitrarily kept on kicking it down the line and we couldn't sell the house. It fell out of escrow. The house was burglarized multiple times. So it's not the best system. I had to double check on the amount of probate judges up there.
I want to say, I think it's 2.
Yeah, I think it might be 2. I think LA is 4.
So we had another question that said, could you tell them one more time what the 3 triggers are that need a trust?
So if you own property, you need a trust, bar none. If you have more than $166,000 in total assets, or if you have minor children, you should have a trust. If you have less than that, if you don't own property, if you don't have minor children, you probably don't necessarily need a trust, but you still need some other stuff. You still need powers of attorney, healthcare directives, and probably at least a will, but not necessarily a trust.
And I believe you hit on this one as well. It says, I own in-state and out-of-state. I would want to put all properties in one trust.
That's correct. So the good thing about your trust is once you set it up, it is an open entity. Think of it like a bank account. You can deposit assets, you can withdraw assets. So if you have your trust set up, you put your California property in, you put your Nevada property in, and then 10 years down the line, say you buy another piece of property. You buy it directly in the name of your trust. You don't need to update your trust because if it's going to go like say 50-50 to your kids, well, that buying this new piece of property doesn't change the disposition of your estate. So we want that to be set up in such a way that your asset list is something you can change on your own. You don't need an attorney to do that. A lot of attorneys want you to do that, and that's not that's not how we operate. Not that we don't want to talk to you or see you or anything. It's just we don't think it's necessary that you have to see an attorney for certain things like changing a bank account or something like that.
There's another one that says, can a living trust entitle properties titled to LLCs and corporations?
Can a living trust entitle properties title? So can they own it? I think is the question. No, because if they're titled to an LLC or corporation, then the living trust can't own that property since it's owned elsewhere by a separate entity. But the trust can actually, you can assign your LLC or assign your corporation to your trust. So if I pass away with an LLC in my name, then I assign it to my trust, and essentially it goes through the trust and according to the trust terms. And that's something that you might want to.
You're claiming the LLC as an asset.
Yeah, correct.
Okay.
Yeah.
And I would like to hit real quick on the pour over will so that people understand that, a perfect example of this is, I come from the title side of business, and we had a gentleman that passed away. He had a trust in place. Thank goodness he had a pour over will in place as well, because he had bought a piece of property and within a couple weeks passed away, and that property never got rolled into the trust.
Oof.
But having that pour over will protected that property because the pour over will stipulated that all his assets would be handled by the trust.
Yep. It's a very important thing to have in place. There's a lot of ways we can get properties and other assets put into a trust posthumously. But we've seen trusts that are created by people who don't know about a pour over will, who didn't include one. And there's the jury's kind of out as to whether that's malpractice by an attorney. It probably could be, just because a pour over will is so easy to create and it's so kind of common knowledge. But it is such an important thing to have. You want to make sure all these documents are in place because they all serve the function of avoiding the courts. That's the goal. Avoid the courts.
Now, let's say somebody has a trust and that trust does not have a pour over will. Can a pour over will be added easily to any trust, or does it have to be done when the trust is done?
And nope, it could be added at any time. Absolutely should be on there. So if you're dealing with anyone, I know that a lot of people on this chat are real estate professionals. Is that correct?
Correct.
Okay. If you're dealing with anyone who is buying property, who has property, and you look at the title and you don't see it in their trust name, that's a good way to kind of follow up with people or to broach that topic as another kind of service or just, thing to talk to them about, which is, do you have an estate plan in place? Do you have a trust in place? And sometimes they'll say, oh, yes, I do. Actually, I'm supposed to put it into my trust, or no, I don't. Well, you should probably look into that because I just went on a webinar and this guy was saying how important it is. So it's another thing to kind of talk to about or to kind of show, your worth through. We've had a lot of title companies where we've done webinars like this, where people can use this as a tactic for touching clients after not talking to them for a while, because it's such an important thing.
Perfect. Another question came in that said, would you ever consider using an irrevocable trust?
Oh, it depends on the reason. Most commonly, irrevocable trusts are used for two different reasons. One would be tax savings. So say you had $5 million that you just never need to touch again, and you want to get a huge tax benefit from it. You take that $5 million, throw it into an irrevocable trust, but you can never touch it. You can never change it. You can never do anything with it unless you have a court order. So basically, you're giving up rights to that money. Unless your situation warrants that, I wouldn't do that. The other one would be if you're trying to qualify for Medi-Cal, Medicare, and not get your property, reassessed or repossessed or anything like that at the end. An irrevocable trust can be used for that to try and protect the property, but it's not guaranteed. Those irrevocable trusts are very expensive. They're usually around $10,000. But the reason that those attorneys charge that amount is there's no guarantee that it's going to work. So they're kind of risking their neck there to hopefully that it's not that the state doesn't look back and do something with your property. But again, there's no guarantees. So for most people who have less than $11 million or $23 million, you need a standard kind of revocable trust.
Yeah, could you real quick, I mean, not in a deep dive, but real quick, just explain the difference between revocable and irrevocable.
Yeah.
Yeah.
So an irrevocable trust is a highly specific trust, one that you can never change. Once you sign it, it is a legal document that needs to only be, or can only be altered by the courts or whatever the terms of the trust say, which is usually the courts. And a revocable trust is one that you can change throughout your lifetime with an amendment or a writing or something like that. You probably want the revocable one because that's the one that you can change as life changes. And I get people every single day who are in here who says, you know, it's either, you know, I made up with my son, I want to put him back in the trust, or, you know, this person passed away, I need to amend my trust. It's very common for trust amendments, you know, usually at least one through your lifetime. So imagine if you couldn't alter your documents, it'd be, you know, pretty prohibitive and pretty frustrating, I'd say.
Somebody has a trust. It was drawn up by a lawyer. Mm-hmm. They don't have contact or communication with that lawyer anymore, and they want legal advice on updating their current trust and stuff like that. Is that something they can come to you for?
Absolutely.
Okay.
So the way trusts used to be done, estate planning and wills used to be done, people would say, oh, this is our family attorney. We're going to go to the reading of the will and, you know, all that stuff. That's kind of a old school. The reason that doesn't work is that I'll give you a little bit more of a deep dive on that. If I create a relationship with a client, my relationship is to that client. When they have kids and if their family inherits properties and stuff like that, I don't have an attorney-client relationship with them yet. So that whole like reading of the will and the family attorney, it doesn't exist anymore because of the restrictions of attorneys. So your attorney doesn't usually hold on to your will. I don't really think it's a good idea either. Some attorneys still do it where we hold on to your estate planning documents, and if you need anything changed, call us and we'll pull them out and we'll go over it together. It doesn't feel great for us. It feels like a conflict. It feels like you're being forced to come back to us. Once an attorney creates your documents, even myself, if you decide to go to a different place, a different person, a different firm, they're your documents. You paid for them. You can do whatever you want with them. You are not stuck with anyone. So there was an estate planner, and I think in Rancho Bernardo, and then another one up in North County as well. One of them passed away. One of them went to jail. A lot of those clients were scrambling, trying to find A, their documents, but B, you know, who can create something new for them or fix their trust or amend their trust. So we get it pretty commonly where we'll get a trust from someone outside of our firm.
All right, here's another question, curveball.
Sure.
And I'll use a scenario like I build a trust. I have a trust done. Down the road, I get married. Obviously, at that point, we start purchasing things and stuff together. Mm-hmm. Is it recommended that my first trust stops with me and we get a separate trust, or can we still combine and alter the one trust to make sense?
You know, that's a great question. And I see that there's another question that just popped in the chat that's similar. So I'll address both of them because this is kind of a mix of family law as well as trust law. So and this goes for your kids who inherit properties as well. Things that are exempt from community property, because California is a community property state. There is no common law marriage in California, despite what people keep on saying. I don't know how this keeps on getting out there. There is no common law marriage. But if you are married, assets that you have before your marriage are your sole and separate property. They are not community property unless you decide to make them community property. Also, if I inherit something and I'm married, by default, that is sole and separate property as well. It is not community property. So the question that was on the chat, and I'll address your question in just a second. So the question on the chat said, if you're married, you own a home as your sole and separate property, and it's in your trust, is it protected from divorce? Technically, yes. So if you're married and you have it in a married trust, but you still keep it in your name in your trust, but sole and separate, that is a protection that you will have from divorce, because if you divorce, then that's still your sole and separate property. On top of that, if you have it in a single trust and you get married, Well, that's in your single trust as a sole and separate property. It is not community property because you didn't change title. You didn't do anything like that. So that's still protected. So going to your question, if you have a single trust and you get married, what should you do, or how should your property be structured? Well, that's up to you and your spouse, because you probably want to keep your separate property trust or your separate trust, and then you can get a married trust if you want as well. So say I have 123 Main Street, and then I get married, and then we buy 123 Birch Street, right? Well, if we're buying that together and that's a community asset, that should go into a community trust that we're both in control of. But the one that's in my name, spouse shouldn't necessarily have control over that unless you want them to. If you want them to be a part of that, then you can transfer that out of your single trust and into a married trust. Usually though, if you have a single trust, you can't just add someone's name on as a married trust now, because you have to change all the language of the trust itself, since it's built to be a singular trust. So essentially people will sometimes revoke their single trust and create a married trust, or keep their single trust and create a married trust and just have joint assets go through the married trust, because you're both in control there.
Right. I think that answered the question, because the conversation the other day was that the wife had a trust. So she's the trustor, the grantor, right, of her trust. And then she had made her spouse, because she ended up getting married, made her spouse the first successor trustee of that trust.
Yeah.
And in case something happened to her, then the spouse had control of the trust.
Usually distributed.
And then in there, the community property that they bought, they just stipulated in their asset list, this is how we want this property divided up. And the other properties, she had already stipulated, this is how these properties will be divided up.
Yeah. And so, sometimes what you'll have is, if you have two people who have two single trusts and some joint assets, then you might have a separate property list, which basically details what each person owns. And then also what is a part of the community. That's kind of like a post-nuptial agreement almost, it satisfies that essentially. But when you have your single trust, usually you can't really convert it to a married trust, but you can have jointly held assets. So this kind of brings up another point. What if there
was a prenup in play as well?
Okay. Yeah. So if you have, what if I have a single trust, my spouse has a single trust, and then we have a joint property that we both bought together? I can put my 50% in my trust. She can put her 50% in her trust.
Right.
So you can essentially, you're like splitting the property, but it's still protecting it from probate. A lot of people will have jointly held properties amongst like 3 or 4 siblings, and they might be renting it out. You got to be careful about something like that too, because unless you're, especially so if you're in joint tenancy, that person's kids, if someone passes away, won't really get their share. And also if someone passes away and it's in tenancy in common, then it's going to go to probate for that portion share or that person's share. So a lot of different scenarios could come up, but it's just important to kind of, get some advice and figure out what's the best plan of attack.
Perfect. I don't see any other questions there. If there is, I guess we can go ahead and stop sharing, and maybe just in case somebody doesn't know where the chat is or what have you, they could raise their hand.
I'm going to put my email in there right now too. So in case anyone wants, to send me an email, they can, of course. I'm happy to answer any questions. This is what I do all the time. So,
so are there any benefits that you guys offer for real estate individuals or anybody to refer clients your way?
Well, legally speaking, I can't. I'd get disbarred, unfortunately, for any kind of anything of value that I would present to anyone. What I can promise, though, is that if there's anyone who, so our normal process is we have a seminar discount, a webinar discount, where we do it for a flat fee, no matter what your assets look like, no matter what your history looks like. Like our lowest prices for a single trust are $2,000. We're usually more around $3,000 to $3,500, but our seminar webinar discount, $2,000 for a single. Married, we drop from $4,500 down to $2,500. So single $2,000, married $2,500. That covers a couple of properties in California for whoever signs up. It doesn't cover the recording fees, which is usually 25, 30 bucks or something like that. So if you have someone that you want to refer to, just say, you know, like, I was a part of this webinar and I want the webinar discount. I'll know exactly what they mean. But if they also just want to kind of kick the tires, ask me some questions, I'm happy to do that too. And I don't charge for, someone sends me an email. I stopped even looking up to see if they used to be a client. I just usually answer the question. So.
Yep. Perfect. And so Justin, his email is in the chat. So you guys can click on chat and get his contact there. And if for whatever reason, you can always reach out to Annie Taylor or myself, and we can put you in contact with Justin if you can't find that. So I guess we'll open it up for one last round. If anybody has any questions, feel free to unmute yourself, ask the question to Justin. Otherwise, I guess we will say thank you at this point.
Well, thank you for having me, and I don't want to talk over in case anyone is speaking up, but oh, go ahead. Oh, nope, okay.
Nothing, Betsy, okay. So go ahead, Betsy, did you have anything?
Yeah, you know, when you buy a property, the lender, will they allow you to put it into a trust right away, or do you have to transfer it in the trust?
I think it really depends. Generally speaking, if you have the right, so kind of a two-sided answer. They should, but sometimes their legal department or their titling is a little afraid of getting it wrong and then getting sued later on. I always tell our clients or anyone who deals with me, if you're buying, selling, refinancing, email me ahead of time and I'll give you exact instructions of what to tell title so we can skip the step of having to create an extra deed. Because if you buy a property and then you have to transfer it to your trust, that's one more deed, one more cost for recording. A lot of times, you know, title or the refinance company won't do it for you. And so they'll be forced to come to me and then I have to charge. So it's, you know, usually.
So what we run into is this, a lot of times is the lender will not do that refinance in the trust name because you're the one qualifying it, not the trust. And so we'll have a double document recording, which is charged by we don't charge any extra for it. We just charge whatever the county charges, which is about $7 a page. And there's usually a couple pages. So it's usually on average $14 to $21 difference in recording, right? Typically, and Lisa or Annie, you're both on the call here. One of you can pretty much pipe in and tell us what you typically do in that situation. I don't want to speak for you.
Oh, you know what? Hang on. I'm so sorry, you guys. I was actually on the other line. What was the question?
So go ahead. The question was during the refinance, if somebody wants to refinance their house, but they want it to roll into the trust in the same process, what process do you usually handle? Is it, you know, you create a double deed?
Yes, we actually we have an instruction that we just, it's an automatic. We just type up the instruction that they want to be in the trust as soon as we close, and we're allowed to do that. So we can just put them right in the trust. And title will actually record it within 24 hours afterwards. So it works out really well.
Yeah, typically as title on the title side is we record today, the refinance, we record the trust document first thing in the morning tomorrow.
Exactly.
Yeah.
And it's all billed through escrow. So there's no, it's like we don't have to not show it. Most of the time the lenders have no problem as recorded afterwards.
Correct. Yeah. All right. I think we answered that question. But I will tell you a lot of times, Betsy, because I know your situation too, a lot of times is, you know, there could be lack of communication of whatever sort. The lender says, no, we can only, you know, issue it in the issuer's name, not in title. And you know, what escrow doesn't understand is no problem. That's what we're doing. But then we're also going to issue another document to be recorded simultaneously the next day that will then roll it into the trust for you, which is still legal and still binding for the lender because we're giving them what they want. We're recording it that way, but then you're just rolling it in. And instead of going through the process, because as a title company, we will only record documents during a transaction. We won't do, you know, any recordings outside of a transaction anymore because there's just too much liability. And to go through like a third-party company, you know, you're looking at, you know, on average $100 to $250 to do that recording to roll it into a trust. And yes, they'll draw the documents, stuff like that. So if you have that, it's a little bit cheaper, but ultimately it's so much easier just to do it at one point and have it rolled in the very next day automatically.
That's why you need a good escrow.
Yes. All right. Any other questions, guys? Annie, did you have anything that you would like to share?
Just wanted to thank Justin so much for doing this. Just so you guys know, I have been working with them. I worked with his dad before he took over, basically, and I've been working with them for, oh my gosh, I think it's like 18 years. They did my very first trust, and then I had to have it amended, and then I had to have it amended again. So I can vouch for them. They are fantastic.
Well, thank you very much. We really appreciate it. We're always happy to help out and, you know, give talks like this too. And I'm here as a resource. That's the main goal here, is to be a resource and to answer those questions that, you know, some people just don't even know to ask, or, you know, situations come up. So we're happy to help, and thank you, Andy. We appreciate that.
Thank you.
Yeah, no, greatly appreciate you taking the time. I know you're busy, and to take even an hour, hour and a half out of your time to, you know, sit here and go through and give us, you know, all the great information that you did is greatly appreciated. So,
of course, I'm happy
Absolutely.
to help. I was gonna say, yeah, anyone, email me if you have any questions, and thank you very much for having me. I really appreciate it, everyone.
all right, guys, thank you again. We appreciate you guys joining us for our Wednesday Zoom and Learn. Hope you guys learned something. I know you did, because I probably get, this is probably the biggest question that I get and that Annie gets out of any of the Zoom and Learns we've ever done. So there's 100 questions that usually come back in regards to trust. So I'm assuming that he answered a lot of your questions, because we only had about a dozen questions afterwards, which is awesome. So thank you. And if you guys have any questions, again, Justin made himself available to you via email. So that was awesome. So again, Justin, thank you for your time.
Of course.
And,
thank you for having me.
appreciate you all joining us today.
Everyone be safe.
Thank you very much.
Thanks, guys.